Intellectual property rights is a specific right given by a government to an individual or organization to protect his or her or their institutional or individual work of creativity, art, literature, or any kind of a process or a product that they have invented. So it is a method of representing the ingenuity of an individual or an organization and to protect their rights from that so that others could not copy what they have designed or discovered or invented, and it is being used extensively by those individual organization or individual. Intellectual property rights comes in various forms and patterns. It could be a patent, it could be a copyright, it could be a trademark, it could be a geographical indicator, it could be all those kind of identifiers that helps to identify an individual or an organization for the creative work that that individual has done. Most people associate IPR or intellectual property rights only with filing patents or getting patents. This is not the right concept of the approach. It includes holistically above all these methods and approaches that we have talked about, all these different forms of recognition such as patents, copyrights, trademarks, trade secrets, process patent, product patents, as well as geographical indicators. What are geographical indicators? For example, many countries or many particular biogeographic region may have a particular dress or a food or a cuisine or something very unique attached to the region, and it is historically, socio-culturally and anthropologically accepted to be a product of that particular region. And if that particular region wants to identify them as connected to the geography and culture of that region, then it's a long run process and an international forum for which the recognition is given, and then once this is being allowed, one can use it as the geographical indicator. Recently, Rasgulla from West Bengal got a geographical indicator as a sweetmeat produced particularly from the state or the erstwhile Bengal province, or a sweet product which is associated with Bengali culture and myth, and for that they had to fight a lot of competition with other adjoining states and international competition. Say for example, within states, Jharkhand, Bihar, particularly Odisha also competed for having Rasgulla as the geographical indicator as their patent, but also for competing with Bangladesh for getting a competent patent is a competition from an international agency. So like this, it happens and occurs in various forms. A difference between intellectual property rights, particularly with respect to giving patents in India and abroad, varies. It is better to say that intellectual property rights is country specific. So what applies in United States may not apply in United Kingdom, and what applies in European Union may be different from African countries, or what applies in India is different from what applies in USA. So the rules and regulation made or processed by different governments at different points of time has been enacted and promulgated as laws by the constituent body or the parliament or whichever elected member body or the lawmakers pass this into a law, and then it becomes, for example, the Indian patent law is filed around 1970. Now, what is the difference between the patent law between India and other countries is that, or particularly with the West and USA, is that India does not allow a product patent, it allows only a process patent. While in United States and other countries abroad, or particularly the Western countries, the IPR is guided mainly towards the protection of both the products and the process. So how to differentiate between this is this like, say for example, USA has discovered a drug after 20-30 years of research, and they have patented it, or a multinational company has patented it based on USA, and then they claim that they will have the exclusive rights for this, selling these products to various countries, to various groups or individuals, where people have to pay their royalties. In case of India, the idea is that no product patent is allowed. So your final product could be a product that you have generated, but if I could decipher a different process, different methods, and I can make this product cheaper for our country, then the patent is allowed on that particular process, not on the product. This has helped Indian pharmaceutical companies to particularly grow and generate, and to keep the cost of medication much lower with respect to Western countries, in the fact that because we do not allow in India any kind of product patent, you can have different products But the Indian government recognizes the process in which, the ingenuity of the process in which they are developed or designed. If you have designed it in a different process, then your patent application is on that particular one. And how long the patent application or the patent rights for a particular product or process is life, it also varies from country to country. In India, one of this process patent is 14 years from the date of filing of the patent, or particularly in case of production process, it could be 7 years from the filing of the patent, or 5 years when the patent is granted, or whichever is earlier. However, this varies from one country to another. Different patent protection years or different patent protection system is applied in various countries. The matter of concern is that we today live in a global village where we have to abide by the rules set by the international standards and international ruling and the governing bodies. The patent laws or the copyright laws, trademarks, etc. are not very well established in India, particularly with respect to copyright, whether it's an author for the particular book, textbook, reading books, reference books, or fundamental research books, edited volumes, or whether it's a work of art, music, compositions, and other kinds of those intellectual things. These are copied extensively. Say for example, in West Bengal, many leading Bengali authors have produced extensive literature which is very high quality. These are sold in corresponding adjacent Bangladesh, where no patent or copyright is, or no royalties provided to the authors. And furthermore, sometimes ghost or fake writers use the name of the living writers, or even those who have passed away, and write fictitious stories using their name as ghostwriters, and then publish it. By the publisher, it is being sold in the market. So sometimes the product or this work of art or literature or fake copies of a particular painting or something is always available in the market. Music are being copied from various sources, whether ethnic groups or folklores or folk music or whatever, and they are being used in movies. Or even in, if you look into the case of Bollywood, there has been many cases where there has been serious complaints and court cases where one individual is pointing towards another for using a part of their music that they have developed, they are claiming, and they're going to the court. Similar things have happened in Hollywood too. They have been identified for forging or cheating by stealing materials from other countries and using them in their movies, or using them in their documentaries, or using them in their own parts without giving due recognition and without paying any royalties. These are gray areas that it's quite remains a very uncovered area under law. In spite of we having laws, these are not very well implemented at the ground level. So if you go into Western countries, you will find copyright lawyers, patent lawyers, and trademark lawyers, the lawyers specializing on various aspects of intellectual property rights. You do not get some highly specialized lawyers or lawyer group. There may be some lawyers who have worked in it, but there is no unique formal specializations on these areas. But as we are integrating with the world, as the whole world is turning into a global village and India is integrated as a part of that global team, there will be more and more pressure on the government of India as well as agencies within India, where they have to follow various strict regulations which are maintained at an international level or following international norms, rules and regulations. Many Indian publishers, many Indian composers, producers flout these rules very frequently. I think they are putting themselves into danger, particularly with respect to international coverage, because many times it may happen that these could be sued in higher courts in other countries, and this will be swept in the charges, unless contested, or if you are penalized, could be in millions of dollars. So it's not worth it taking the risk. The consciousness and education and awareness about intellectual property rights in India is still at a very novice stage. There needs to be very much various forum discussion, various applications and education and awareness program, both from government and non-government society agencies, for the people in India to understand these various patent laws, the importance and implication and the significance of patents, intellectual property rights, trademarks, to understand your own right, like why you would be able to defend your copyright, why you are losing your copyright. All kinds of these important information are actually lacking in this country. So these need to be revived. There needs to be an educative awareness about this program, and the law needs to be strengthened and applied more rigorously at the ground level. Having a law without implementation at the ground level does not make any sense. So these are the challenges of intellectual property rights, particularly with respect to India. But as time is changing, artificial intelligence and all other information technology and computer science, telecommunications are making huge progress. The social media and other media forms are getting more and more powerful. I think it is very, very important that we have become very cautious about the intellectual property rights, so that no one can steal or violate our copyrights, as well as in the same way no one can, that I also, we as an individual or as a group or an organization does not flout this role from the perspective of international studies or from international rules and regulation. Previously, the basmati rice was patented in Texas. The turmeric, the chemical components of turmeric, was also patented in US. Indian government, in collaboration with a lot of the intellectuals and lawyers, filed cases which ran in various thousands of dollars and millions of dollars, and finally won the cases where it was resolved that these are originally originated in India, so it could not be patented and stuff. So this is a case of biopiracy. People are trying to steal our bionatural resources, and unless we are aware of our rights, unless we strengthen intellectual property rights program and awareness in India, we will be losers in the long run. Thank you. Shoykot Kumar Basu, Bureau Report, Kalinga Chronicle TV.